Thank you very much.
My lady.
Good morning.
Yes. As you know, I appear with Melanie from Mr. Bonner for the appellant, who are the claimants or Part 20 respondents in this action. Melanie from Mr. Day, Mr. Alquist, Mr. Wilden appear on behalf of the respondents or the Part 20 claimants. I hope you've had the ability to read the skeleton arguments. Which
I think we've read very widely, so don't.
Most grateful. Which will speed things up a lot, I'm sure. As you're aware, it's an appeal from a decision of Mr. Justice Bryan in the Commercial Court, giving permission to the Part 20 claimants, who are referred to just generally as Tavistock for ease of reference, to amend their defence and counterclaim to introduce a new claim of breach of confidence against the second claimant concerning what's called the Titan MPS. And as you will have seen, an MPS is a model portfolio service, essentially a bundle of investments in a variety of publicly available funds which are intended to meet a particular investment objective, which is defined both by reference to the style of the investment, active, passive, ESG, sustainable, and by reference to a particular level of risk, which is fixed in advance. And the investments can be and are tweaked on an ongoing basis, if I can put it that way, to try and maintain the level of risk which has been advertised for the particular portfolio. They're not much different in principle from any fund that operates at a particular risk level, save that they sit in a particular category, and within that category you get different risk levels, and the idea is the investor can thereby select a particular risk level for the category that they want to invest in. The levels are defined from 1 being the most risk-free to 10 being the most risky, if that's an appropriate term to use for investments. So a customer can simply select sustainable portfolio risk level 5 or 7, to use. I don't know whether you've had an opportunity to look at the fact sheets that set out the nature of these investments. Might be worth just briefly turning those up. In the core bundle behind tab 13, which is the defence and counterclaim, at page 312 is exhibited. Well, there are a number of them exhibited, but the one I'm going to show you by way of example is the Abacus, which is the Tavistock MPS ESG profile 7, and you'll see it defines underneath the heading. So this is the fact sheet from February 2024. A very general investment objective, setting out the aim of the portfolio to increase in value over a minimum of 5 years, invest in a range of asset classes, combination of capital growth and income, out of investments such as dividends from shares and interest in bonds. So it's pretty broad-ranging statement. Oddly enough, doesn't even refer to the ESG nature of the fund, but I guess that's taken as read. And the reward profile is risk and reward profile, as you see on the left-hand side for this one, is 7, and that's pitched between 1 and 10, as I've explained. And then you'll see the way they allocate assets is published in those 2 graphs towards the bottom of 312. This one has, by the looks of it, some 16% in bonds of various kinds, 84% in equities of various kinds, split between emerging market and developed market, none in cash, none in commodities, and then it sets out regional allocations. And you see on the left-hand side towards the bottom, top 5 holdings, which are, of course, the investment funds in which this particular portfolio is invested. This one, as published by Tavistock, doesn't tell you how much in each, but it just gives you the top 5. So one is Schroders, one is CT Responsible UK, etc. And then over the page there are various rankings. So here we find some ESG information done by reference to the established and standard MSCI ESG quality score, the bar chart on the top, carbon risk, impact solutions, controversial business activity involvement. So the prospective customer can have a look and see if that's appropriate for him. The equivalent Titan one, you will see at page 303. Similar kind of things, an investment overview towards the top. This one actually does explain the nature of the investments that are going to be entered into. Core investment themes that have passed our in-house sustainable investment policy via third-party manager funds across global markets. Then there's the reference to capital growth, etc. And you'll see there towards the bottom, again, that publishes also top 5 holdings. As we'll see when we look at them, there's only one actually in common between Titan and Tavistock, which is the CCLA one. Asset allocations, again, which are split between stocks and bonds, and cash and other, in this case, in a very different way from what we just looked at, but the same sort of general idea of an NPS. So that's the kind of things that we're talking about. These are, as I say, obviously public documents intended to provide information to investors. And the balances that we look at in terms of asset allocation will, of course, change from time to time, depending on what the investment experts decide is useful on a month-by-month basis. Turning to the overall dispute between the parties in the context of which this counterclaim arises, you'll have seen reference to this. I don't intend to spend too long on it, but it puts the thing into some kind of background. The two companies, if I can put it that way, Titan and Tavistock, or the two groups of companies, have fallen out over what happened after Titan bought a chunk of Tavistock's business in 2021 under a share purpose agreement, which is referred to as the SPA. As I say, it's not really necessary to have a detailed understanding of the nature of that claim for the purpose of this appeal, but in essence, it's this. Prior to the SPA, Tavistock operated a series of open-ended investment funds, which were called the Acumen funds, which you'll have seen reference to. These funds were owned and operated by a company called then Tavistock Wealth Limited. And Titan, as part of the deal in 2021, purchased the shares in Tavistock Wealth Limited, which changed its name to Titan Asset Management Limited, which is now, of course, the second claimant in these proceedings. The second claimant thereby, as controlled by Titan, thereby controlled the Acumen funds, and the investment team with all their expertise in setting up and operating these funds, of course, remained at C2, now at Titan Asset Management Limited. Prior to the SPA, Tavistock Wealth Limited, C2 as they were then called, operated a series of model portfolios which were called the Tavistock portfolios, and those ones invested exclusively in the Acumen funds. Obviously there were a variety of Acumen funds that could be adjusted from time to time, but they also offered another model portfolio service in which retail investors could invest their money in return for a fee. It's referred to as a DFM fee. Again, those invested nearly all their money at that time in the Tavistock portfolios and thus in the Acumen funds, but a small amount was invested elsewhere. And again, that was all run by the investment team at Tavistock Wealth C2. And under the SPA arrangement, Tavistock were to keep the MPS business, which had, of course, always been operated through Tavistock Wealth Limited, therefore C2, which was now owned by Titan. C2 therefore had the investment expertise which had been built up setting up and operating those funds in the past, and would be continuing to operate the Acumen funds. So it was against that background that the parties entered into the OMA, which is the subject of the claim, which is known as the Outsourced Management Agreement, which is shortened to OMA throughout the documents in this case. And it might be worth just again having a brief look at that, because that forms the basis of some of the claims which are in issue before you by way of breach of confidence today. And that's behind tab 17 of the core bundle. And you'll see it refers to Tavistock Asset Management Limited, now the second defendants, and Titan Asset Management Limited, who are the second claimant, formerly Tavistock Wealth Management Limited. And it gives, by way of background, the qualifications of Titan as an investment manager, and in B states that Titan has agreed to provide Tavistock Asset Management with investment management services to enable TAM to deliver its MPS as defined below, including any future adaptations. Then there's a reference to Tavistock Asset Management Limited, which is intended in due course to be authorised by the FCA, and then there's a reference to duties of good faith. There's a reference to confidential information in the interpretation section as being all information disclosed by either party to the other in connection with the agreement, either labelled as confidential or which would reasonably be considered confidential. There's some reference to intellectual property rights, including trade secrets, and then a definition of MPS, which is here the Tavistock Model Portfolio Service, providing discretionary investment portfolios to MPS investors for which they pay this discretionary fund management fee. The remaining bits which are of interest, if you turn over to 490, you will see it sets out the responsibilities of Titan, which are to provide investment management services to TAM in respect of the MPS, And then it sets out the current constitution of the MPS. So it's got to these Tavistock profiles that I talked about already, blends of acumen funds, which of course are the, now Titan is operating, acumen MPS, whole of market tracker funds and ETFs, active range, passive range, and SRI, which I think is socially responsible something range. But obviously ESG, sustainable, those kinds of MPS, I think, are wrapped up in that definition. There's then a reference to Titan using its reasonable endeavours to provide investment management services in a professional workmanlike manner. And the obligations of Titan are to ensure that sufficient information is provided to Tavistock on a timely basis to enable the proper provision of the MPS, cooperate and provide reasonable assistance, enable provision on TAM's platforms, act in a timely manner on any written instruction, support the development of any new MPS, provide such assistance as TAM may reasonably require. So Titan are being expected to use their expertise to provide all the necessary information to Tavistock to help it operate its MPS. And as far as Tavistock are concerned, it goes on at 2.4 to go into a little bit more detail about the obligations, including at 2.4.3, produce such reports and analysis as may reasonably be required. And then at 3, we say what Tavistock are going to be doing, and they're going to be managing and delivering the MPS in line with the most recent client terms, determining discretionary management charges, bringing in the money, paying investment management fees to Titan, representing 50% of the discretionary management charges, executing changes to the profiles, etc. So it's very much Tavistock are operating at the retail platform end, making the MPS available, holding it, charging people for the investments. Titan are providing the investment expertise to help in that operation. And then 5, there's a reference to confidential information. Each party shall keep the other party's confidential information confidential, and then shan't use it, for any other purpose, shan't disclose it to a third party, except as permitted by this clause. And then there's a reference to limited cases of statutory obligation, etc. I think probably those are the only parts that we need to look at for present purposes, except perhaps it might come in later, section 20, that nothing in this agreement shall be deemed to establish any partnership or joint venture. So it's a service provision agreement, as it were, not a partnership. And each party is acting on its own behalf and not for the benefit of any other person. So that's the OMA. As I say, the parties fell out over various matters which are of peripheral relevance to this appeal. In brief, Tavistock set up a company called Asset Lab Limited, which is said to have operated an investment management business in competition with Titan. And Titan says that Tavistock had orchestrated a series of high-value redemptions from the Acumen funds, which of course are Titan's funds, instead diverting the money into alternative funds or portfolios in breach of its duties under the SPA. And it's also said that Tavistock had purported to terminate the SPA, which was a repudiatory breach of contract. So that was Titan's claim. Tavistock's defence was that activity was all a reaction to Titan failing properly to manage the Acumen funds, which had declined in value and had resulted in investors wanting to pull out. and that itself, they say, was a repudiatory breach of the agreement. And in addition, Tavistock brought counterclaims in relation to various activities of Titan said to be in breach of the SPA, including buying companies said to be operating in competition, and a separate claim about poaching an opportunity which Tavistock had been offered to buy a business from the LEBC group. All of that is in the case already, and the action's due to come to trial, I think, towards the end of next year in the commercial court, with an estimate of 5.5 weeks? 7 to 8 weeks. Sorry, 7 to 8 weeks already. Which brings us to the proposed new counterclaim, which is the subject of this appeal. And as you've seen, that concerns a model portfolio service which is said to have been set up and operated by Titan on its own behalf between 2022 and 2024, which we refer to as the Titan MPS. That MPS has active, passive, and sustainable versions, each with risk ratings from 3 to 8 in the 1 to 10 scale. I say said to have been operated because Titan's evidence is that the Titan MPS and the portfolios associated with it was never live at all, say live in inverted commas, in that no one ever invested in these portfolios or could ever have done so. They were essentially being run in this period on a shadow basis to seek to build up a track record of what would have been achieved by the funds using the investment decisions which were being taken on an ongoing basis, with the idea that it might then be able to be launched to the public. The point seems to be that unless you can show a track record in a portfolio, you won't get people to invest in it. And that seems to be, that particular point seems to be common ground, although there seems to be a dispute between the witnesses as to whether 1 year is enough for that or whether you need 3 years or more. So there's that dispute. The Tavistock don't accept that it didn't go live, and so that particular dispute remains. Now, what is clear is that fact sheets were being created and published for the purpose of the MPS by Titan. Each month, the investments would be reviewed by the investment team at Titan, and notional rebalance is applied so they could track the value of the notional funds. As of August 2024, this MPS ceased to be maintained, and therefore has not been for the last 18 months or so an actual MPS, whether live or not. Titan is now operating an MPS which is known as the tailored MPS through something called Titan Square Mile, but that's not the subject of any dispute. Obviously, if what Titan says is right, there wouldn't seem to be a lot of point to this claim. If the MPS was never live, it could hardly have caused any significant damage or created any profits. But Tavistock says it doesn't accept that it wasn't live. But as far as we can see, it's got no evidence to contradict Titan's case that no money was invested and no revenue was received. Despite, as I say, despite the statements by Titan that this wasn't a live fund, the claim is still sought to be pursued. And if permitted, there is no doubt that it will open up a completely new aspect of what is already an extremely complex, lengthy and costly dispute. It will involve substantial disclosure which wouldn't otherwise be given in this action, and evidence as well about the whole setting up management and operation of the MPS by Titan, and indeed to some or a great extent by Tavistock, the decision-making processes that went into the investments which were chosen and the rebalances that were chosen by Titan, and that will be, we submit, obviously a time-consuming and costly process. And we also submit it's particularly the case here if the claim is allowed to be pursued on the extremely broad basis on which it is now being asserted, because of the almost unlimited breadth of the claim and the lack of particularity, allowing disclosure and evidence to be properly targeted to the specifics of the information said to have been misused. And that's confirmed by the fact that since the order of the judge below, there has been exchanges about the disclosure which will be sought in respect of this claim, and Tavistock seek, not surprisingly, very broad disclosure, running to essentially any document passing between the parties that might comprise confidential information, and practically any internal documents of Titan concerning its MPS. If I can quote, they're seeking presentations, memoranda, formal briefing notes, board executive committee materials prepared in connection with the Titan MPS, financial projections, investment analyses, strategy papers and forecast in relation to the MPS, and all documents or text relating to the Titan MPS which was uploaded to various of Titan's domains. And I say that by way of explanation as to why this proposed amendment was regarded by Titan as so significant as to justify an appeal against the judge's decision to allow it. And you will have noted, of course, that permission to appeal was granted despite the provisions of paragraph 4.6 of Practice Direction 52A in relation to appeals against case management orders. And we submit this issue is certainly of sufficient significance to justify this appeal. And ultimately, the question before you is whether the judge was justified within the bounds of the discretion which is given to a trial judge in finding that the proposed amendment to the counterclaim gets past what I might describe as first base of providing an adequate basis upon which the claim should be allowed to proceed. With that, can I briefly turn to the legal principles upon which we rely on this appeal, and they fall into two categories, as you'll have seen in the skeleton argument. The principles applicable to any application to amend a pleading, and the principles particularly applicable to the setting out of a cause of action for breach of confidence. And if you've got our skeleton argument, I wasn't going to do more than show you what we quote at paragraph 24. I don't think there's any issue between the parties on these fundamental propositions from which we've taken simply from the White Book. The first is a citation from Kawasaki, KK, and James Kemble, which is a neat summary of the burden on a party seeking to amend, that a proposed amendment must be arguable, carry a degree of conviction, coherent, properly particularised, and supported by evidence establishing a factual basis. And then there's a reference to the principles to be applied when exercising the discretionary power to grant permission. And those, importantly, are from Emersey and Leslie, containing sufficient detail to enable the other party and the court to understand the case being advanced, and disclosing reasonable grounds on which to bring and defend the claim. And then a reference to Lady Justice Asplin in Elite Property Holdings, that the court can, and we would submit, should reject a version of the facts which is implausible, self-contradictory, and not supported by the contemporaneous documents. And we'll come back to that when we look at the way this case is pleaded. And it's appropriate for the court to consider whether the pleading is coherent and contains the properly particularised elements of the cause of action. So the watchwords we submit are coherence, degree of conviction, proper particularisation, supported by evidence establishing a factual basis, and sufficient detail to enable the court to understand the case being advanced. And those principles we submit have particular resonance when one considers the other strand of authorities on which we rely, which concern pleading a breach of confidence claim. And as we say in the skeleton argument, the courts have always been particularly sensitive to the difficulties caused by lack of proper particularisation in the case of breach of confidence claims. And the reasons for that have been set out in multiple authorities over the years, including by the Court of Appeal in the well-known cases of John Zink and Searle and Celtic. They were reviewed and explained by Mr. Justice Laddie in Ocular Sciences, which we'll look at. But we can take most of this from the passage in Ocular Sciences and the commentary of Lord Justice Arnold in Selgarden Shenzhen, which is at tab 5 of the authorities bundle. And you can turn to paragraph 32. I don't know whether you've read this as part of your preparation, but I won't try and read through it. But there's a long quote there.
I'm sorry, which paragraph are you
Sorry, paragraph 32. It's
you.
the red marked part on page 247. Sorry. He starts, it's well established, the claim for misuse of trade secrets is important for the claimant properly to particularise the information which is alleged to be a trade secret to be misused. And then he cites Mr. Justice Laddie in that famous case of Ocular Sciences. And the key parts of this are that from the second line of that quotation, it's well established that breach of confidence actions can be used to oppress and harass competitors and ex-employees, careful to ensure the plaintiff gives full and proper particulars of all the confidential information, and if they fail to do that, the court may infer the purpose is harassment and may strike out the action. And then the second paragraph, if a plaintiff wishes to seek relief, it's his duty to ensure the defendant knows what information is in issue. And then not only the reason given in John Zink that misuse is a serious allegation, but for two other reasons. The scope of the injunction is the next point. Unless it's properly identified, an injunction in the terms sought is of uncertain scope, difficult to enforce. And then secondly, and importantly, we submit the defendant has to know what he's got to meet. He may wish to show the item of information matter of public knowledge. His ability to defend himself be compromised. The plaintiff can rely on matters to which no proper warning was given. may be particularly damaging abuse of process. And this, in paragraph 33, there's another citation from another decision of Justice Laddie, pointing out the fact that proceedings are only at an interlocutory stage doesn't justify less precision. Defendant must be told what he's accused of misusing. Of course, it goes on to note the plaintiff isn't locked into his case. If you are able to give proper particulars, you can, at a later stage, of course, add some further ones if it's appropriate to do so in the light of the stage the litigation has reached, or remove them if you discover that there was never any basis for it. So, I mean, just as a matter of generality, when one's considering confidential information concerning a business and how it operates, of course, any business operates in a vast sea of information all the time, generated day by day and minute by minute. No doubt the vast bulk of it is either public knowledge or part of the general skill and knowledge of its workers, which it would be very hard to claim any rights in, or even essentially trivial or ephemeral, and can't be asserted as in any sense belonging to the business. But within that sea, there is sometimes what's referred to as crown jewels, or some highly specific trade secrets. It may be a particular scheme which has been developed, which has been kept secret. It's a possible business opportunity, or in a technical case, it may be a recipe or something of that order. Information has to have that quality of concrete definability to be something that can properly be made the subject of a claim, because only when it is defined in specific ways is a defendant able to say, what's my response to this? Am I going to say it's public? Am I going to say I haven't used it? Am I going to say it's part of my ordinary skill and knowledge anyway? Am I going to say it's trivial or ephemeral and therefore not hasn't got the quality of confidence about it for that reason? In other words, even to satisfy the first requirement of a confidential information claim as set out in Coco and Clark, which Mr. Lord Justice Arnold cites at paragraph 21 of this authority, for the court and the defendant to be able to examine the question whether the information has the necessary quality of confidence about it, which is the first Coco and Clark principle, one has to know with precision what the information is. And it's for that reason, as well as all the others given by Mr. Justice Laddie in the cases that we've looked at, that if an allegation is to be made that an employee or a business associate has taken some information which is confidential and has misused it, it's simply not good enough to plead entirely generally in the kind of terms that one sees in some of these authorities, such as all information relating to an aspect of that business. Such a plea is abusive in our submission because, first of all, it inevitably includes a vast amount of information which is plainly not protectable at all, because it was public or trivial or part of general skill and knowledge, and therefore fails the basic rule of a pleading, which is to put forward a coherent cause of action. And second, because as a matter of procedure, it is impossible for the defendant to start to address the case properly, that is to say, to take a position by way of defence on the particular aspects of information. And that is a point, whether we need to turn it up, we could turn it up. In Ocular Sciences, Mr. Justice Laddie makes precisely that point. Tab 1, page 360 of the report, which is page 74 of the bundle, at lines 21 to 25. The defendant must know what he has to meet. He may wish to show that the items of information relied on are matters of public knowledge. His ability to defend himself will be compromised, etc. I think, in fact, that may have been included in what Lord Justice Arnold cited. So we submit those are the very significant authorities, making it absolutely clear that in a breach of confidence case there is a particular obligation on a party to consider the nature of the cause of action and to plead with precision so that the case can be understood. And with that, could I turn up the pleading, which is the draft pleading, which is in issue before you. And we can divide the analysis of the pleading into two, I think. The main part being the identification of the confidential information, and I'll come on later to the allegation of misuse. So it's tab 13, page 243 of the core Bible. And it starts at, yes, at 153E, announcing that following and pursuant to the OMA, Tavistock AM communicated information necessary to implement the Tavistock MPS to Titan AM.
Just pausing there, Tavistock AM is Titan AM, isn't it?
Tavistock AM is the second Part 20 claimant. It used to, it's confusing because Titan AM used to be called Tavistock Wealth Management Limited, not Asset Management Limited.
Yeah, okay.
In this respect, the parties are, I think, properly identified. Such information form part of the model portfolios described in paragraph 41 within the Tavistock model portfolios. And then it says, look, when we're looking for detail, this information included instructions as to which investments were to be onboarded for the Tavistock MPS. So immediately there is vagueness here. First, because there's no limitation to the instructions. It's merely said that the information included instructions. And that information is just generally described as the information necessary to implement the Tavistock MPS. So even at this point, the case is pleaded at a very wide level of generality and not properly cut down to any specifics. And then we would ask ourselves, well, what instructions and where and how? And we're told this included, by way of example only, instructions, that is to say, instructions communicated by Tavistock to Titan, as we see from the original sentence, by way of example only, instructions contained within, and then there's a reference to a set of email exchanges referred to as the investment emails. So just two general points here. One is, this is the only point we will see in this pleading at which any specific communication is ever referred to. And secondly, this is what's defined as the investment information, although this is merely an example, it is said, of what the investment information actually is. But obviously, since this is the only specific example that is given, it is highly important to an understanding of what's going on in this pleading. Just to be clear, there's a reference here to onboarding of investments. And as we'll see from the evidence, onboarding is a process whereby a platform through which a particular fund is traded. And we see with these emails a third-party platform, for example, called Platform One, ensures with the fund manager that its fund will be available for purchase by an investment company such as Titan or Tavistock, as and when they want to do so. So it's essentially setting up these investments so that if the company wants to adjust its funds or move into this particular investment, it can do so simply by going online, no doubt, with the platform and placing the necessary order. Of course, you might onboard many funds, but not invest in more than a few of them. The emails are said to have been sent by David Chandler of Titan, and then there's a reference, that's little Roman 1, and there are 2 identified there, and then there's a reference to email exchanges between third parties and James Peel, again a portfolio manager of Titan. There's a red light starts flashing at that point because, of course, even on its face, this doesn't appear to be identifying information passed by Tavistock to Titan. So there is something odd going on immediately. And if we can, since we're here, have a look briefly at these emails. I don't know whether you've had a chance to look through them. It's just another one of these annoying things where you have to go backwards through the email chain. But there are several chains here. If I can just help you briefly with it. If you can start at 296 of that tab. You'll see there's a set of emails starting on the 20th of September 2024. So this is from David Chandler of Titan to an Andrew Kenyon. I've forgotten. I think he's at Aberdeen or Aberdeen or however you're supposed to pronounce it when they'd removed all the vowels. I think they put the vowels back now. So this is, as you see, hi Andy, please can we onboard the following ISINs to be used in Tavistock/Titan models? And then there's a list of various funds that look on the face of it as if they're sustainable ESG type funds. And then there's another one of the same day at 20 minutes later at page 294, again from Mr. Chandler to Aberdeen, noting that he'd submitted a fund request. Could he confirm receipt? And the significant thing here is these are copied to Mr. McGregor of Tavistock. So it's not sort of something being done in secret here. This is, on the face of it, Titan. It's looked into possible investments. It's found these ones. It's decided it might want to invest in them. Tavistock might as well, because, and this is part of the duties under the OMA, so it's saying make them available for both parties. And it's telling Mr. McGregor that that's been done. So that's that one, and the rest are pretty much the same. So if you go back to sorry, it carries on, I think, that chain. Miss 293, Aberdeen says, confirm that's available, and ask the fund manager to be contacted directly. You must specify it's being made available to both companies. There's another reference at 292. It's the same, seems to be the same chain. There's then another set starting at 290, going back to 285 to the same effect. This time it's to do with a Schroders EM value fund. Mr. Chandler to Aberdeen, asking it to be onboarded and available for both companies, copying in Mr. McGregor, same again, and that goes all the way back to 285. All these emails copying in Mr. McGregor, and then we have 281 going backwards, which seems to be doing the same thing, but in relation to Aviva, starting right at the bottom of 281. Hi Andy, hope you're well. You had a great bank holiday weekend. Can we onboard Schroders value? So obviously they're expecting Aviva to make it available as well. And then 278 backwards is a set of emails in relation to a request of BlackRock, most of which come from someone at Aegon, but the thrust of this seems to be Aegon asking BlackRock if their Sustainable Emerging Markets Fund can be accessed by Titan and Tavistock. And again, this is copied to Mr. Peel of Titan and Mr. McGregor of Tavistock. And then we have 274 backwards, which from June 2024, this time it's Mr. Peel of Titan. So he's someone else in the investment team at Titan. And he's asking Platform 1, which is the company I referred to earlier, to onboard various ESG type funds for Titan and Tavistock. Again, copied to Mr. McGregor. In fact, at 271, there's one email from Mr. McGregor, I think is the only one in this set, but this is addressed to Dominic of Platform 1. You'll see it at the bottom of 271. And he's just saying, oh, I can't see one of these funds available to me. I think there were like 5 that had been made available, and he couldn't see one. The LNG Future World, please can you investigate? And the other ones, he said, all do seem to be available. So that's all seems to be carrying on perfectly normally. And then we have 269 backwards, Mr. Peel, again getting initial investment amounts waived for Titan and Tavistock for a particular fund, again copied to Mr. McGregor. So we've whipped through that, but we've made this point several times. It's never been denied by the other side. There's nothing here that involves any information being imparted to Titan by Tavistock at all. And it's therefore utterly inconsistent with the pleading, which alleges precisely that this is an example of information being communicated by Tavistock to Titan. And indeed, that element of the pleaded case is repeated numerous times in the pleading. For example, 153Q, the whole nature of this case is about information being imparted to Titan by Tavistock. And indeed, that's a characteristic of the cause of action pleaded under the trade secrets regulation. It's a critical part of the case and the only documents which are relied on do not support it. And that's why we say, as well as being vaguely expressed, this case is incoherent and self-contradictory on the only occasion where some degree of particularity is engaged in. This isn't just some kind of error or peculiarity in the particular documents that have been cited. It's quite plain from the evidence of Mr. Raven that the onboarding process certainly does not represent information created or imparted by Tavistock. We've looked at the OMA and seen what the responsibilities of these parties were, and it was Titan that had the expertise in investment management, and it was Titan that was making recommendations to Tavistock as to the funds that it might want to invest in. That's the whole point of the OMA.
Just to be clear, I think you've explained it, but I'd like to make sure I've understood properly. The onboarding does not represent any decision or advice as to what investments should form part of any model portfolio or in what proportion. It's simply identifying the pool of investments from which such decisions may be made. Is that right?
Yes, and that's exactly what we see in these emails that are said to represent the onboarding process. The word onboarding is used occasionally in the evidence. You'll see the way it's put. If I can show you in Mr. Raven's evidence, which is in... So Mr. Raven is Managing Director of Tavistock Investments Plc, so the first defendant. And so he's the only witness from Tavistock who's given evidence in support of this application. And he sets out in paragraph 11 what's going on here, if I can put it like that. So if you've got 154 of tab 10 of the supplementary bundle, it's a slightly odd section in that he sets out in paragraph 9 some evidence from Mr. Gailani on behalf of Titan, where you'll see he says he understands the investment team, so that's the Titan team, was typically involved with identifying potential investments, carrying out due diligence, examining and analysing financial information, and ultimately making a decision regarding which products or funds to make available on the Titan platforms and recommending to Tavistock, make available on the Titan platforms and recommending to Tavistock which products or funds to make available on their platforms, as to which, see paragraph 71. And then, oddly, Mr. Raven says he disagrees with this characterisation, but when he gives his account of what's going on in paragraph 11, it appears to be pretty much exactly the same. So if we just read what he says in paragraph 11, apart from the fact that he says Titan was appointed as sub-investment manager, which actually the OMA does refer to it as the investment manager, but there you are. He says Titan's responsibilities were to identify potential investments, so potential investments for inclusion, carry out due diligence, and liaise with platforms to ensure the funds are available to Tavistock for potential inclusion in the Tavistock MPS. And that's, of course, what we can see in these emails, exactly what's going on. And he then says, contrary to Gailani 2, Titan would then report to the TAM Investment Committee and the Abacus Investment Committee each month, outlining the investment case for any potential change in Tavistock MPS, including the addition of new funds. Well, that does seem to be pretty much what Gailani 2 was actually saying. But anyway, yes, everyone agrees that that's what was going on. So it's for TAM to make the ultimate decision as to whether they're going to move an investment. But what's going on in these emails is just they're being available. So as it says, if accepted, Tavistock would then implement the relevant change. And because the investments have been onboarded, of course, it can do that fairly readily. So it seems that everybody agrees the underlying rationale for these emails and what's going on here is it's Titan's information reflecting the results of its expertise, skill and knowledge that these are potentially good investments may be useful. And Titan is doing its managerial job of making sure the funds are going to be available both for its own investments and also for Tavistock if it wants them. It's transmitting the information to Mr. McGregor and it's using the information both for its own and for Tavistock's benefit. But the simple point really from our point of view is there's clearly not information imparted to Titan by Tavistock as pleaded, which is the critical foundation of the cause of action. And you can't find, in fact, a single piece of information here being imparted by Tavistock, even though they were copied into the email chains. And beyond that paragraph, there seems to be no plea which actually identifies any other information which is said to be confidential. We get, in fact, in the pleading, if we skip over the copyright infringement case, which raises very different issues in relation to these fact sheets that I've dealt with briefly in the skeleton argument, but I wasn't going to trouble you with this morning. The breach of confidence case is said to be set out from page 246 of the core bundle in the pleading at 153M. And first of all, there's an entirely broad allegation of use of confidential information and or trade secrets. And then we have this odd paragraph 153N, which says in the light of commercial sensitivity and value of each of the investment information. So we've seen the investment information defined as instructions as to which investments were to be onboarded for the Tavistock MPS. We've already dealt with that. Seems to come down to nothing as pleaded. Then it says, in the light of the commercial sensitivity of that information, the MPs, that is the model portfolios, and the Tavistock MPS, and of the context in which and purpose for which they were created, unspecified, each part of the Tavistock, and then we get capitalised, Tavistock MPS information was inherently confidential, save insofar as it was deliberately published. That confidential information is referred to hereafter as the Tavistock MPS information. So first of all, this seems to be an entirely circular plea, because the first reference to Tavistock MPS information at the top of page 247 doesn't refer back to anything, and yet that is then made the basis of the defined information, that is Tavistock MPS information in bold at the end of the paragraph. That is, we submit, incoherent. We just don't know what that information is supposed to be if it goes beyond the investment information. And then there's this attempt to sort of narrow as a matter of form by saying save insofar as that information was deliberately published. So presumably the pleader is thinking, well, I can't just allege all information because some of it might have been published. So as long as I say if it wasn't published then it should count, then I'm okay. But of course what you're not doing by pleading in that way is providing any useful information to the defendant as to what it is you say has not been published and has been kept secret and is therefore justified of protection. So we submit it's not good enough to try and save a pleading by simply formally excluding matters that you could never have protected in the first place by making an entirely general statement by way of exclusion. You have to, if you're going to be complying with the rules on pleadings, have to be properly specific. So we say none of that helps, and there is no further attempt to define or limit the information which is relied on for the purpose of this action. I should, at this point, refer to the interpretation that my learned friends appear to be putting on the definition here of Tavistock NPS information for completeness, because it's tab 4 of the core bundle, page 47. They seek to say that they rely on the Tavistock NPS information, which we just looked at the circular definition of. But they say this comprises the Tavistock NPS, that is the model portfolio service itself, whatever that means. And they say, oh, well, that's described at paragraph 40A. So on this basis, apparently one's supposed to go back to 40A, which is at page 191 of tab 13, which defines in general terms what essentially what an MPS is, but in this case the Tavistock MPS. And apparently all of that in its entire generality is said to be confidential information, unless it had been made public. I mean, that is an extraordinarily broad allegation, which in our submission could never satisfy the rules of a breach of confidence pleading, but also is not a realistic reading of the paragraph, which refers to the value of the MPS, but doesn't suggest that every single piece of information connected with the MPS is relied on in the context of this action as having been misused. So there's that, and then they also say, so they refer to the investment information, making sure they say it's not limited to the investment emails, and then at the top of 48 of the core bundle, they say it also comprises the model portfolios, not only the whole service, but the portfolios themselves. And they say, I think that's because of the reference in the pleading to the sensitivity and value of the model portfolios. They say, we've got to then go back to paragraph 41.1 of the pleading, which just defines essentially what a model portfolio is, a basket of investments, etc. But again, presumably it's being said that this is any of the investments, save insofar as they're made public, but there's no attempt to explain whether there are sensitive investments, which investments are said to be secret, so that the defendant could say, well, I never took those investments, or anything.
And I can see that a model portfolio, which presumably consists of I don't know, tens, hundreds of individual funds.
We don't know.
Which in certain proportions are designed to give
Yes.
a certain investment outcome, is the product of research, etc. And its composition could well be confidential. And
Yes.
certain things are then published about it in a fact sheet.
Mm-hmm.
So those things lose their confidentiality, but that tells you, for example, only what the top 5 investments are.
Yeah.
Doesn't tell you how many investments are, doesn't tell you what the proportions of the overall investment those 5 investments operate. I mean, you may well say in response that that's not the case they have pleaded, but that would be, wouldn't it, a coherent and sustainable case to plead as to what was confidential information.
Lord, yes. I mean, one could imagine how a case could be pleaded here if there was any basis for it as a matter of inferential misuse. We'll come to that. But it could be said, in April 2023, our model portfolio ESG 7 comprised the following set of investments in the following proportions. That was secret, that had some value, and you have lifted the lot. You've just replicated it or something.
Yeah, well, there would be a question, I suppose, of degree if you had made some changes, but whether you were essentially copying it or not.
I mean, several points to make. One, of course, that's not the way the case is pleaded, and if it were pleaded in that way, it would greatly limit the nature of the cause of action and any investigations that were going to be carried out. Secondly, it would give rise to great difficulty where, and it would again have to be pleaded out, where it's plain as here that Tavistock are relying on Titan to advise it as to what it might do with individual portfolios. And thirdly, of course, these are being adjusted on a month-by-month basis. Is it actually being said, and it's certainly not what's pleaded, that Titan somehow got to know of the precise balance of funds in these portfolios, exactly copied them and adjusted them on a month-by-month basis to mirror what was going on. I mean, if that was the allegation, that would be highly specific, and one could obviously address it. The other final difficulty is when one looks at even the top 5 that we know about investments, which have been set out in the pleading and which are published. They're not the same. So if the top 5 aren't the same, and the balance of assets, as I showed you when we briefly looked at these documents, is not the same, one can see how such an allegation just would never fly. It's just hard to imagine how it could be made in this case. And we would submit that's why Tavistock have not made such an allegation. They know that these assets are different, and the idea that one replicates the other when just on the face of the fact sheets the balance of investments is very different. It's just never going to work. And when we'll come to it, there is no suggestion where one would expect to see it by Mr. Raven that such an inference could be drawn from the facts that he is aware of. But yes, I certainly don't dispute that there could be, clearly there could be confidential information here. And one would expect in a pleading to have it set out in what could be confidential schedules so that one could see exactly what it was being contended for. A bit like in a technical case, one would plead recipes, formulations, blueprints, whatever it was that one was saying comprised proper confidential trade secrets. So that's the pleading as it stands. Of course, when my learned friends look at the nature of the pleading, as I say, they take us back to the definition of model portfolio service and model portfolio. Those refer in the most general terms to things like investment strategies. That's paragraph 40A. Appropriate asset classes. It is extraordinarily broad and vague. So it's not saying just a particular set of investments on a particular day. And there's no attempt to explain what the investment strategy is if it goes beyond the investment strategies that we've seen set out in the fact sheets. So there's no ability for the court or the defendant to put that kind of claim to the test in terms of confidentiality or misuse. And so far as the definition of model portfolios at 41.1, of course, as we've been having this discussion, every portfolio operated by every company who has a model portfolio service is a basket of investments, as defined in 41.1. But what is it that the confidential information is supposed to be here? Pleading refers to strategy and risk levels at 41.1 set out in a publicly available fact sheet, which doesn't seem to be a good starting point. So is the strategy something more than this? If so, what is it? Where is it defined? And how could the vague statement of that kind, which is now said to be part of the definition, amount to information at all? Or form the basis for an injunction. And we say it simply doesn't help my learned friends to point to these broad definitions in 40A and 41.1 because they don't serve to define with precision the information alleged to have been taken or misused. I mean, just for completeness, on my learned friends' skeleton on what this is all supposed to mean. There are quite a few paragraphs that follow. They say in 33 the pleading is deliberately broad because the position is that all of this information was confidential. They say that's not legally or commercially surprising. And they then refer to the OMA and to Titan's investment team, you'll see towards the bottom of that paragraph, continuing to provide many of the same services. That is to say, the analysis of information, selection of portfolio of investments, etc. But of course that's contrary to the pleaded case, which is that this is all information flowing the other way. And there's then a reference to the judge who, I'll come to that later, but the judge we submit takes an extraordinarily broad view of what the case is supposed to be. And then there's a reference to Coco and Clark at 36, saying that this is far from unusual. And there's a reference to Coco and Clark, where the judge is talking here, Mr. Justice McGarry, about where information of commercial industrial value is given with an avowed common object in mind, etc. recipient carrying a heavy burden if he seeks to repel a contention which is bound by an obligation of confidence. So this is simply about whether an obligation of confidence exists. It's got nothing to do with the definition of the information for the purpose of pleading out a case. So we say that doesn't really help. And then we just get a series of slightly different definitions, which again we say is telling. Now they're talking in 37, you'll see, about investment information, this time small letters, and information about the structures of the MPS, again undefined. And then 38, they say there's a clear plea, the information included instructions as to which investments were to be onboarded. Well, it might have been clear until one actually looked at what they were relying on as those instructions, because they weren't instructions flowing from Tavistock to Titan at all. And then just a general reference to disclosure. And then in 40, we now learn that the claim is about Titan copying investment information in real time. Again, undefined and not reflected in the pleading anywhere, etc. Then there's a reference in 41 to excluding public information, which I've already dealt with. And then finally, at 42, there is a reference to Mr. Raven's evidence in a long passage in paragraphs 26 to 27 of his witness statement, which is at tab 10 of the supplementary bundle. But the key here is the paragraph that immediately follows. So you'll see what he's talking about in terms of investment decisions, etc. But he concludes in 28, for these reasons, the work of the investment team was generally confidential at the time it was conducted. But the investment team, of course, is the Titan investment team. He's dealing here with Mr. Gailani's evidence, and the investment team, capital I, capital T, that Mr. Gailani is talking about, and indeed is referred to at various parts of this witness statement, is the investment team at Titan that had remained there after the SPA. So we don't really see how any of that helps with the problems of the pleading. So we submit that the skeleton argument in a way neatly makes our point, that Tavistock are unable to fall back on any specific information they've identified in the pleading. They make pretty wild and woolly claims using terms like selection of investment strategy, real time, except where made public, none of which are sufficiently specific to be properly addressable by way of defence. And we say the whole pleading of subsistence of confidential information is hopelessly vague and ambiguous. The only point at which it descends to particularity is self-contradictory and apparently hopeless on its face. Defendants have had a long time to get this pleading right. The objections to it have been knocking around a long time. They've made no further attempt to do so. And we submit this part of the pleading does not satisfy the ordinary requirements of a statement of case of this nature. I should turn now to the pleading of misuse, because it formed some part of the judge's reasoning. And that's set out at 153U. And it just requires a little bit of analysis. So it's at page 248 of the core bundle. So this is the plea of inference that Titan used the Tavistock MPS information, which we looked at, in creating and administering the MPS. The precise nature and scope of use is outside the knowledge. So, for example, they could have said, every month you simply replicated our MPS, but they don't say anything like that. They say they don't know. But then they say, pending disclosure, we plead as follows. So here are the basis of the inference. The first is the onboarding of the investments, which I've already dealt with in my submission, that provides no basis at all for a case inferring misuse of confidential information. It shows no more than Tavistock had identified some potential investments and were telling, Titan had identified some potential investments and were telling Tavistock that they were making them available for them as well, in accordance with their duties under the OMA. And then secondly, they refer to similarities of the fact sheets, which seems to be a reference back to the copyright claim, and the underlying investments described in the fact sheets, examples of which are set out in Annex 8. We submit that neither of these, even on their face, could give rise to an inference of misuse of confidential information, not least because both of these relate to public information. So the investments described in the fact sheets, examples of which set out in Annex 8, are comparisons of the top 5 investments which are made available to the public in the fact sheet. And of course, the fact sheets themselves are public documents. So there's no confidential information involved in 153U2 at all. And in any event, the point that we've made in our skeleton argument, when Mr. Raven considers what Titan have said about how it set up the MPS, and said it was did it largely based on the Acumen funds. Mr. Raven's evidence was, well, that's all very well for the active and passive, but not for the funds that you didn't have in Acumen. That appears to be a reference to the sustainable funds. But when one looks at the sustainable profile, if one's got tab 13 at page 324 of the core bundle, this is the top 5 holdings information which is pleaded for the sustainable profile. There is only a single investment there which is held in common. So even on its face, it doesn't look particularly arguable at all. But again, in 153U.2, one would expect to see, if this was going to be the basis of an inference, some explanation of why a particular similarity, let's say one of these investments, the CCLA Better World Global Equity Fund, was in some way of great significance in the suggestion that confidential information must have been taken. And we simply don't understand how any of that is supposed to give rise to an inference. But it goes further than that. because aside from the need to properly plead a case, a party seeking to amend must, as we've said in our paragraph 24, support the claim by way of evidence establishing a prima facie factual basis for the allegation. And we submit that if a case was to be based on inference, particularly a case where it's not at all obvious on the basis of the pleading how that inference is supposed to arise, one would expect that a witness with knowledge of the facts and the business would explain, when the application to amend was made, how it was that that inference was supposed to be properly drawn from the pleaded facts, so the court could consider whether the case had a real prospect of success. And significantly, Mr. Raven, who is the only witness of this kind, does not support the alleged inference pleaded at 153U at all. He doesn't mention the emails or explain what their significance is to him in terms of making an inference of misuse. Nor does he mention the alleged similarity of investments, which you might expect him to do if he considered that there was some great significance to the top 5 investments which are set out in Annex 8. The furthest Mr. Raven goes, if you've got his evidence, by way of evidence on I put it loosely, evidence on this point. Paragraph 32 of his witness statement. So that's Sup Bundle 10, page 158. And he says he understands that. He says Tavistock alleges that Titan misused confidential information. He understands that Titan has criticised the degree to which Tavistock has provided a list of exact confidential information. He says Titan was in an advantaged position with access to core workings, including live information. Can't say for sure what information copied or misused, but in my experience of MPS setup, the information which would have been helpful to Titan is likely to have included. And he then sets out 3 things which aren't pleaded, obviously, which is not helpful. We'll come back to that point. But what he doesn't say is absolutely critical here. He doesn't say, I infer from X and Y that this information must have been used, or that there is a real chance that this information was misused. All he does is set out some information which would have been helpful, which doesn't make the point at all in our submission. And it is telling that he doesn't go to the pleaded points on inference. He just makes no point about those at all. So, no statement he thinks Titan did make use of information based on some inference from known facts. And even there, the things that he says would have been useful are, again, extraordinarily broad, albeit they're slightly narrower than what we've seen so far. But there are no specifics of what is going on here, and also doesn't really seem to be entirely consistent with his paragraph 11, where he says, well, the investment advice was in fact being given by Titan and not Tavistock. So we say they had an opportunity to do the job one would expect when making an application to amend and explaining why there was a prima facie case, but it was not taken. And it specifically was not taken in relation to the matters which have been pleaded by way of inference. Tavistock deal with that point, I should say, at paragraph 53 of their skeleton. We say this is actually quite a telling paragraph, because having got a witness who understands all about what was going on and is obviously in a good position to express an opinion, and he doesn't express that opinion. They say in 53, for these purposes, that is to say whether the claim had real prospects of success, it doesn't matter at all whether Mr. Raven states he personally has reason to believe. But what matters is whether the court can draw a reasonable inference. Though how the court is supposed to be in a better position than the witness who was actually there and understands the significance of what's going on is unclear. But what they go on to say is very telling. In circumstances where A, Titan had access to the information, B, it would have been helpful, C, they did create an MPS, D, refused to give disclosure, the court can draw the inference. Now, in our submission, that is completely wrong. First of all, of course, it skirts round the question of particularity completely. This is a separate point. But even as it stands, the idea that one can simply draw an inference from the fact of access to the information, the fact that it would have been helpful and you did set one up, and then you'd refuse to give disclosure, that gives rise to a pleadable case, essentially changes the burden of proof. It's a case where you've got no actual reason to believe that it was used. That paragraph is missing from this account. All you've got is the defendant saying, well, I'm not going to give you access to my books on the basis of this entirely speculative claim. It would reverse the position if one imagines a typical ex-employee case, of which there have been many before the courts over the years. The ex-employee always has access, generally has access to confidential information. If he sets up in competition, no doubt the information would have been useful. Is it to be said that the cause of action therefore arises just because the defendant says, well, I'm not going to give you access to my books? In other words, if I leave and set up in competition, I am obliged to give you access to my books in order to avoid breach of confidence action. We say that's completely inconsistent with the approach that the courts have always taken in these cases, which is that the burden is on the claimant to say, I've seen what the defendant is doing, I've got some evidence from which I can say there is an inference here of copying. I've analysed the defendant's product. I've noted that the defendant has approached every single one of my customers, could only have done that using a confidential customer list, whatever the case may be.
All they know about your product is what's in your fact sheets, is that right?
But certainly that's all they've pleaded, yes.
So you say, well, actually, when you look at the top 5, there's a little bit of overlap, but not very much, to which they might have responded, but haven't. Well, all those others might not be in our top 5, but you've actually picked what were our numbers 6, 7, and 8, for example. So it rather looks as if you're closer to ours than a mere comparison of the top 5 would suggest, but they've not made that kind of case.
They haven't made that case. I would submit that that would be pure speculation unless they had some basis for it. I mean, if you haven't hit the top 5, the idea that you will have hit 6, 7, and 8, I suppose it's possible.
No, what I meant was
that,
what I meant was that the numbers which are in your top 5
yeah,
are very high up in
right.
theirs, but not in their top 5, and therefore the fact sheets don't correspond. But given that the top 5 may
yes.
each represent quite a small proportion of the fund, it could give rise to a better inference than you say is there at the moment. Yes,
I think I would put it 2 ways. One is that isn't the way they put their case. But secondly, a mere assertion, well, we think you've taken 6, 7, and 8, is pure speculation. There's no inferential basis for that. Unless you've got a witness who can say, well, there are all these other facts that I'm going to rely on, from which I draw an inference. I was going to show you Shenzhen, which is quite a useful contrast when it comes to the way this kind of case could be pleaded, both by way of particularity and by way of inference, because there was another case where the claimant obviously didn't know the precise recipes and formulations which the defendant was using for its battery separators. It's at tab 5 of the authorities bundle. But there was a lot of material upon which inferences could be raised of likely misuse. So the evidence, I won't ask you to read the lot, but it starts on page 240. It was all about Dr. Zhang, who was a senior technical employee of Cellguard for 11 years. And as you see in paragraph 7, he left Cellguard and said he was going to work for GE in California, and they didn't make battery separators. And then it later transpired that he'd gone straight over to a company that did make battery separators called Senior in China. Not only that, he did that under a false name, Mr. Bin Wang, as you see at the end of paragraph 7. Then in paragraph 9, there were lies told at trade fairs. Mr. Shi of Cellguard asked Senior about Dr. Zhang. He was told that nobody of that name worked for Senior. Well, that might be true, I suppose, because he changed his name. And then Dr. Zhang got in touch and said he wasn't working on battery separators. But as it says at the end of paragraph 9, a picture was then published of Dr. Zhang at Panasonic, obviously buying batteries, major battery manufacturer buying battery separators. And Senior said, oh, well, Cellguard were an aggressive litigator, and the judge said that wasn't borne out. And then we've got the pleaded case. Actually, I'm not sure whether it was pleaded or not. It was the argument that was made based on the evidence, again by way of inference. One sees at paragraph 37 of the judgment.
There seems to be a pleading at 35, as far as I read this.
Yes, so paragraph 35...
set out in a confidential annex, which looks as though it might have been a pleading.
Yes.
At least part of it.
I'm grateful. Yeah, that's a reference to the, and I was going to refer to that as well, to the way in which confidential information has been defined for the purpose of the pleading, which was highly detailed by way of the nature of the materials, processes and equipment that went into the recipes the documents that set out the recipes, etc., etc. And then there was this specific binder that was relied on, which is set out in paragraph 36. But the point I was making on inference is at 37, little Roman 4. So this is the way you might set out an inference. First stage was to contend that Senior's, that's the Chinese company's share of the dry separator market, had gone up sharply after Dr. Zhang arrived. Second stage was to contend that this increase is due to an improvement in range and quality of Senior's products. And the third stage was to say that was as a result of Senior's acquisition and use of Selgard's trade secrets. So they've got an ex-employee who's behaving in a highly suspicious way, and they've got a dramatic increase in quality of products, which then enables the Chinese company to compete on the UK market, coinciding with the arrival of this highly experienced person who's in possession of the trade secret. So that's a typical way in which one might begin to say, I have a real prospect of success here because I've got an inference that confidential information has been misused. And here are the surrounding facts. In the present case, we don't have anything like that. And indeed, given the opportunity, Mr. Raven just fails to even suggest that there is a basis for such an inference. And we submit, therefore, they haven't made good their obligation to persuade the court that there is an arguable prospect of showing that Titan had misused any confidential information, even regardless of the specificity of the pleading, which is, on our submission, completely inadequate. Before I leave that before I leave the pleaded case, can I turn to another way in which Tavistock now seem to be trying to put the case, which I shall submit is certainly not pleaded, nor on the face of it arguable. You can see it in the Leonard Friends Skeleton Argument tab 4, the core bundle, behind at paragraphs 74.2. Well, actually, it starts at 45.
Sorry, you said it starts at...
So 45, all information is confidential.
Sorry, page or paragraph?
I'm sorry, paragraph.
Thank
you. Which, when we read it, appeared to be just a sort of generalised statement of an obligation of confidence. But when one reads it more closely, one sees it refers to all information, not simply information imparted by Titan, which is by Tavistock, which is presently the pleaded case. But even there, it doesn't appear to be saying very much. But then when one turns to 74.2, on page 59, we see Tavistock's case is said to be that the OMA and duties and equity did preclude Titan from creating its own rival MPS. So there seems to be a suggestion here that it is not the case that Titan are able to produce their own MPS at all. Indeed, this is also supported by what's said at 55.1 of Malone and Friends. We say it's not suggested that Titan had to act exclusively for Tavistock, couldn't onboard the same publicly available fund for its own benefit, and they say, no, we deny that. And so at 74.2, it gets as far as saying, couldn't create your own rival MPS. Now, short points on that. I mean, that's a fairly wild allegation, which is fairly anti-competitive on its face. It's not supported by any term of the OMA. No such term is pointed to, and were we to go through it, we can't see, there's no reference to exclusivity, anything of that kind. As we've seen, it's not a partnership or a joint venture. On the face of the OMA, the fact that Titan may have given Tavistock the benefit of its advice that a particular fund might be worth investing in this month, there's no reason on earth why Titan can't use that expertise for its own benefit as well. But perhaps even more significant, of course, any such case would plainly have to be pleaded. And there is no pleaded case of an implied term of the OMA that would prohibit Titan in its entirety from setting up an MPS of its own, whether in competition or otherwise, with Tavistock. So the case is shifting in terms of its definition, but it also seems to be shifting in terms of the cause of action, which is now turning into some kind of breach of a notional exclusivity clause. And in our submission, there is no basis for that.
And I picked up, I think, in my reading that
Yes.
the Tavistock were relying on the pleading at page 386 of the bundle.
Yeah.
I may have missed, it may not be exactly this point, but this is part of their
Oh, yes, in the reply.
reply to defence to counterclaim.
Yeah.
And I thought that in this regard they were saying that they relied on 18B1.
Sorry, I'll try and catch up with this. Yes, well, there's an assertion, but no basis for it.
They don't refer to a term of
Pleaded.
the
No,
agreement
no,
in support of it.
no.
And as far, so your argument is that as far as the pleaded case goes, it all comes back to the alleged duty of confidentiality and the obligation not to use confidential information for any other purpose.
That is to say, in part, the way it's set out in the pleading, and indeed in the OMA, information flowing from Tavistock to Titan, or imparted by Tavistock to Titan, which is the whole way in which the case is pleaded. This is suddenly, I think, in the skeleton argument, an attempt to
This seems to be
set up a
referring to information which Titan itself may have come across in the course of carrying out its functions.
Yes.
And it doesn't, and seems to be broader than information which has been imparted by Tavistock to Titan. So part of your argument is that the amendments which are in issue here are all about information imparted by Tavistock to Titan. Is that right?
Yes. And if another case was to be alleged, it would. I mean, it's not immediately apparent how it would work, because these are accepted to be expert investment managers in an investment team at Titan. which is clearly monitoring the market, having a look at funds all the time, and the suggestion that there's some kind of term that if they come across a fund which happens to be useful to a client, Tavistock, they can't use that for their own benefit. We're getting close to a kind of trust argument over information.
Well, it might be relevant that it is Tavistock and not Titan who make the ultimate investment decisions. Titan,
yes,
no doubt, makes some recommendations, but it's the Tavistock people who say yay or nay.
yes,
If the position were different and it was Titan essentially creating a Tavistock fund,
yes,
one might think it would be reasonably easy to imply a term that they must, as it were, do their best for their client and not set themselves up in competition with their client. But
one
I
could
think
imagine.
it seems that it is
Yeah.
certainly Tavistock's case, and perhaps yours as well, that it's Tavistock who make the decisions as to which recommendations to accept and which not.
Yes, certainly their evidence is very clear on that. That's what they say. I mean, this is very half.
I'm sorry, you carry on.
I'm sorry. It's a very half-baked sort of, not quite emerged from its chrysalis argument that seems to be floated here in the reply, and the odd paragraph of the skeleton argument in our submission. It doesn't reflect the pleaded case. It has obvious difficulties and would need to be set out very carefully in order to be understood and properly pleaded to.
Sorry, can I just then ask this, which relates to the question that was just asked? Was there any obligation on Titan to provide a specific or dedicated team of people for this particular function?
Not under the OMA. I think there was a known investment team that were there, but I think that's the Titan investment team that do all their investments and all their research that had remained after the SPA. But there's no term of the OMA, nor I don't think it had been suggested that there was a dedicated Tavistock team working solely for their benefit. Can I just turn now to the judgment? Obviously, our overriding submission is that, given what I've shown you, given the pleading, the law, and the evidence, a finding that this pleading was adequate and should therefore be allowed to proceed by way of amendment was not one which a tribunal could reasonably reach on the facts before it, even given the broad case management powers of a court asked to consider an application of this kind. To permit it would be to flout the rules of pleading and the guidelines which the courts have consistently given. And that's the overriding basis for the appeal. I should, however, tell your lordships and my lady where we think the judge went wrong in his analysis insofar as it goes. And there are four particular points, I think, some of which merge together. The first is that on a number of occasions the judge appeared to consider that a pleading which simply made entirely generalised allegations was satisfactory simply because those general allegations could be readily understood as general allegations. So if you've got the judgment which is behind tab 10 of the core bundle, this is really the whole of the passage between paragraph 130 on page 124 and 141. So he says, stepping back, he says in 130, the nature of the allegation is relatively straightforward. And he then just sort of makes a few generalised points that the pleading goes on to allege the defendant's confidential information was used, but one sees it again at 136 and 137, where the judge is simply setting out the nature of the pleadings, having set out the OMA, and then he sets out more the nature of the pleadings, 138 and 139. And then again at 141, he says all of that involves a relationship between two parties whereby it was contemplated confidential information would be transmitted, with provisions that it shouldn't be used. An allegation a rival product was set up using that information by the claimant. Standing back, it's clear enough what the allegations are that are made, and that that pleaded case is not only coherent but gives rise to a cause of action that has a real as opposed to fancial prospect of success. It's clear that the allegations are made in extraordinarily general terms. One can't doubt that. But what the judge isn't doing is addressing the case that we were putting, which was there's no precision, there's no specificity, and one can't properly address a case of that nature, nor does it grapple with the need to be particularly careful about a claim where the information appeared to originate from Titan and not from Tavistock. The whole point about 153E, which again was a point that was put to him but he doesn't deal with. And then also 157, I think, on this point. The version of the facts which advanced is in no view implausible. It might be thought it arises naturally from the nature of the relationship and the information which is being communicated. It is not self-contradictory. There are references to contemporaneous documents which the defendants say support their case, but again, nowhere is the judge looking at those documents and actually addressing the criticisms of that apparently self-contradictory case which we were making. So that seems to be the general approach the judge was taking, that provided you could understand the allegation in its entire generality, it didn't really matter that it wasn't specific or that it might be self-contradictory. The second point is the judge's approach to Mr. Raven's evidence, which is at 149 to 151. Here he sets out at 149 the reference to 153U, which is the pleaded case on inference that we've looked at. And he then says, Mr. Raven explains in 29 to 32 why that is the case, that is to say, it's to be inferred that the information was used. And we've already looked at Mr. Raven's evidence. Of course, he doesn't explain anywhere the basis for the inference. He simply points to some other information, not that in 153U, which he says might have been useful, but the judge doesn't point that out, nor does he analyse Mr. Raven's evidence really at all. And he then goes on to say at 1451 that I'll come back to the disparity in knowledge point. Such material is augmented by the actual factual evidence from Mr. Raven, who has direct evidence of the relevant material concerned. Wouldn't expect the level of detail that's set out to be in Mr. Raven's statement to be included within the pleading, but it's further material that allows the claimant to understand the claim. Well, number of points there. I mean, Mr. Raven's statement is not the pleaded case, nor can it be regarded as being the pleaded case. It could be used to support an inference, but it doesn't form part of the pleading. Nor is it right to say that the very limited detail that Mr. Raven gives wouldn't be expected to be included within a pleading. That we submit as a remarkable statement. One would expect a pleading in a case like this to be highly specific and to include far more detail than Mr. Raven goes into. More generally, the judge's approach to the inferential nature of the claim. I've dealt with points on inference already, which I don't want to repeat, but the judge deals on a number of occasions with what he calls a mismatch of knowledge, or the obvious fact that in a confidential information case, a claimant can't be expected to know exactly what's gone on in the defendant's business. And he refers to that numerous times between 156 and 162. We submit that the mere fact that there is a mismatch of knowledge does not mean that the claimant gets off the pleading obligations scot-free. That's clear from, for example, the passage I showed you from Mr. Justice Laddie and CMI cited in Selgard at paragraph 33. Even in an interlocutory stage, it's incumbent on a claimant to be able to plead the case properly so it can be understood. It could be adjusted later, but you still need the bare bones of a pleading with proper particularity.
Would you, on that point, would you accept that there may be a difference between cases where someone's seeking an injunction and a case like this where an injunction isn't sought, and the question is then essentially a case management one about timing, because you might have an order for particulars up front. You might say, well, we'll require particulars after disclosure. There's a number of ways of doing it.
I would certainly say it's particularly egregious in a case if you're seeking an interim injunction, and it is utterly unclear what the injunction is supposed to cover. In such a case, clearly the court shouldn't grant an injunction at all, because one of the requirements of an injunction is the defendant knows what it can and can't do. But many of the points which are made about the importance of particularity of pleadings concern, for example, the defendant's ability to put forward a defence, properly to plead back to the allegation, and also the nature of harassment, where, of course, if you make an entirely broad and general claim, you can then use that as the basis to seek very wide-ranging disclosure, because you simply have not focused the claim in a way that enables the disclosure to be focused. And both of those are very good reasons for requiring a proper pleading at the outset of litigation, so that the court can know it's not a fishing expedition right from the beginning. And I've shown you the way that was done in Selgard. Yes, of course, in Selgard they were looking for an interim injunction, but they had the basis for an actual plea, which we say there's no attempt to do here. What the judge does here is repeatedly refer to the fact that the case is inferential and that disclosure will be necessary before full particularisation. But of course, he's done so without having considered whether there was any logical or evidential coherent basis for drawing an inference of misuse at all, even though that was a case that was being put to him. either from the matters pleaded or from Mr. Raven's evidence. And we submit merely saying that it's a case of inference and that it's the defendants, the claimants here, that hold most of the cards, as he does in 159, is not an excuse for a unparticularised and incoherent pleading, and the judge should have recognised that. And finally, of 119 to 127, the judge would place his reliance on the pre-action correspondence. Again, I don't want to take you through all that, but the point is quite a general one. The fact that Titan didn't play ball and hand over all its internal documents concerning its MPS for Tavistock to trawl through to see if it could make out some pleadable case of misuse seems to have played some part in the judge's decision, C159. We submit that's very much a bootstraps argument. Clearly, if there was a reasonable basis for an inferential case, then the court could take this kind of thing into account in determining whether the pleading is sufficiently precise. And there's no doubt, as Lord Justice Arnold says in Selgard, that it is relevant to consider the fact that the claimant can't know precisely what the defendant did. But in order to get a pleading of misuse off the ground, you have to at least have, in our submission, the basis for an inference that has to be set out either in the pleading itself or by way of evidence. And if you haven't got that sufficiently to put in a pleading or in evidence, then you clearly didn't have it in the letter before action. And you can't use the letter before action and the failure to respond to excuse yourself from the need to identify some basis for an inference. It's not for any defendant, as soon as he's accused of anything, to immediately come forward and say, yes, please, look at all my internal documents. So
the judge seems to have placed some weight on the fact that in the pre-action correspondence, your side highlighted limited paragraphs of the proposed amendment.
Yes.
Not including one that you've focused on in your oral argument, both before the judge and today.
Yes, I don't.
Any significance to that?
I think that's not. I don't think that's right, because what happened was.
Well, for example, paragraph 162.
Yes. So what the way the correspondence went, we can go through the correspondence if necessary, but essentially Quinn Emanuel said, well, your claim is far too disparate and diverse, and we don't understand what the confidential information is. And what came back in response was 153E. So in other words, it was the defendants, the counter-claimants, asserted 153E. So when I came before the judge, naturally, indeed I was invited by the judge to consider 153E, but that was the nature of the case that was being advanced in correspondence. So I think that's how it happened.
So you say,
right?
I'm sorry.
Yes.
So I was going to say, is it right that when what the judge calls the Quinn Emanuel letter was written,
Yes.
the draft did not include paragraph 153E as we have it, and that only came later? Because
Yes.
if that's the case, then the judge seems to be making a mistaken point in paragraph 162.
No, I think. Yeah.
That doesn't seem to be what he says in. Sorry, it's one. I'm sorry, I've lost it again. One. It's around 1, 2. He quotes from the letter. I think he quotes from the reply, doesn't he?
Yeah.
Sorry, I've lost it again. Sorry, at 126, he quotes from a letter from the defendants, which is an answer to this, but they then referred to 153E in that response.
I think that was the point I was trying to make.
So your point is you ask about some other paragraphs and then they say, well, see
Yes.
153E.
So we ask about 153N, which apparently is the definition of confidential information. We've looked at that because it's the first paragraph where the Tavistock MPS information is apparently defined. And 153Q, which I've now forgotten exactly which. That's those are the circumstances. That's the information being imparted to Titan. So we ask about those two fundamental paragraphs and say, well, that's incredibly general. What you're talking about, and then they come back and say the only specifics they give are 153E, which is what's set out in paragraph 126 of the judgment at 5.4.1. And that was why I focused naturally on 153E, as well as the fact that it is the only point where any specific information is cited. I think that's how it transpired. I mean, it's true that Quinn Emanuel were addressing the generalised paragraphs, and then the DAC Beechcroft came back on the 3rd of December, referring to 153E. That's just a week or so before the hearing.
So anyway, you would say that ultimately we have to look at the pleading as it stands, and it either does the job or it doesn't.
Yeah, we say you can't really found a decision here on pre-action correspondence. It doesn't add anything to the pleading. After all, it's simply referring back to the pleading. I do say the judge's apparent criticism of me for referring to 153E is in the circumstances a little misplaced, because that was the very paragraph upon which it seemed that the case was now being hung, and therefore required proper examination. Yeah, I mean, throughout the correspondence, of course, there's a repeated attacks on the generality of the information, which is the foundation of this appeal. My lady, my lords, I think that I've completed the submissions I wanted to make to you on this appeal, unless I can help you any further.
Thank you, Mr. Purvis.
Thank you very much.
Stay.
Thank you. A couple of words of warning before I delve into the detail, which I'm sure the court will have very much in mind. You are being asked to look at only one aspect of the claims that were before the judge. And as you're aware, the MPS claim in particular has two facets. So it has the breach of confidence, but it also has the copying of the fact sheets. What happened before the judge is that Titan tooth and nail opposed every single amendment that we wanted to make. There's also a breach of confidence claim in relation to Aspira, which has been allowed to go forward. And why do I say that's important? Well, it is important to look at this in the round, as the judge did. it's repeatedly been said to you this morning and this afternoon, it's a proposed new counterclaim. The judge has allowed it in, and this is an appeal. And we do say that it's invidious to pull things out without being clear as to what will be going to trial. What will be going to trial, irrespective of this appeal, will be the court examining the fact sheets and seeing if they were copied, one from the other. And indeed, to a certain extent, Titan accepts there is a degree of copying. They say that was legitimate copying. But that is something that the court will have to look at. Some of the other points that were made to you, the time estimate is based on this claim being in the trial. So that is a false point to the extent it's relevant to this court. But importantly, what is said to you in essence is that we don't have the basis for an inferential case in relation to breach of confidence. This appeal is very much focused on that, and it's focused on an alleged lack of proper particularisation. There's an immediate difficulty, though, with many of the submissions made to you this morning, which are based on us particularising when Titan know, because this was clear from the very first letter of claim, that we cannot do so without them handing over certain information to us. We did not ask for some blanket disclosure from them. We asked for some very specific disclosure which would have enabled us to give the very particulars that has been explained to you this morning and this afternoon that should have been provided. So can I just take you to the letter of claim, because it's...
Just on that, you say they know that you can't particularise, but does there need to be a distinction between particularising what you say was the confidential information and particularising the use that they made of it, which are distinct? You ought to know. In fact, I think you do say you do know.
We do.
Yeah, query when
we do.
You've spelled it out.
Yes.
What your confidential information was.
Yes. We do know what our confidential information was, and we do know, and I'll take you back to the provisions of the Outsourcing Management Agreement, because we say those obligations under that agreement are far wider than has been submitted to you, and we say that we have an arguable case on that at trial, and I'll show you why that is, because when you look at how this was defined, it's clear that what Titan were doing under the OMA, they knew that they were not allowed to take that and use it for their own benefit. We are not saying, if I can just shoot this false argument immediately, we're not saying it's an exclusivity. Of course, Titan could go off and create their own NPS using publicly available information, but it's very clear from the OMA, or what I have to show, which is that I have a more than fanciful case of showing at trial, that under that OMA, Titan were getting 50% of the fee, but the quid pro quo for that was they were not to use that information in relation to Tavistock's NPS for their own benefit. And the only purpose for which they could use it was for promoting and enhancing and managing and assisting with the Tavistock NPS. That's always been pleaded, that's always been our case. It's a very, very simple case, which is that Titan refused to pay for the Tavistock NPS. It had a value, it has a commercial value. They then instead used information that they obtained through performing the OMA to launch the Titan NPS, which I'll show you was launched publicly and was taken down in response to our letter of claim. And this came out of the blue for my clients. They had no idea. And the extreme similarity between the two, which we set out from the very first letter of claim, gives rise to not merely an arguable inference, a very strong inference that what Titan did was to simply copy our MPS. So if I can take you to the supplementary bundle, and if we go to page 3, this is a letter written as long ago as the 28th of February 2025. And this is the letter of claim. So this precedes the pleading. And this is part of the pre-action correspondence which the judge had before him, which he read, and which was then part of the hearing. And if we look at paragraph 4, page 4, we see the background, which again hasn't been made clear to you, but was argued extensively before the judge. This was a product, Tavistock MPS, which Tavistock had had since 2014. And it does have a commercial value. That's why
I'm so sorry, were you?
It's paragraph 4. Since 2014, Tavistock has offered an MPS to investors.
Tab 1 of the supplementary.
Tab 1, I'm sorry. I was in
Sorry.
tab 3. Right, thank you.
Page 4.
Thank you.
Since 2014, Tavistock has offered an MPS to investors. The Tavistock MPS is comprised of a series of different investment strategies and risk levels which can be selected depending on their suitability for each investor. In relation to each investment strategy, Tavistock and the Tavistock Group invest significant time, expertise and resources in identifying and selecting appropriate asset classes and product types from a wide range, including unit trusts, OEICs, investment trusts, structured products, ETFs and commodities. And then that gets to the result that an investor is able to invest in a broad range of products within the asset classes without the investor or their FA having to conduct their own due diligence on each product or construct an appropriate investment portfolio. And so absent the knowledge that Titan gained of how the Tavistock MPS worked whilst carrying out those services under the OMA, Titan would have been in the position of anyone else in the market looking at any publicly available information about the Tavistock MPS. Instead, they took and used the inside information, which they were already being paid for under the OMA, and used that to create the Titan MPS. And they did that in secret until we saw it being publicised and we began asking questions. And then at 5, we see some of the background set out there. The Titan Group didn't want to purchase the Tavistock MPS, and therefore the ownership of that product was transferred within the Tavistock Group to TAM. It's important to note that the Titan Group had no track record of managing funds, wasn't well known in the wealth management industry prior to its acquisition. This acquisition was therefore a critical juncture in the Titan Group's entry into this sector. And again, that's important when we look at the Titan versus the Tavistock MPS, because we do say they took our knowledge and expertise and used that illegitimately and contrary to the terms of the OMA. And you then see set out the terms of the OMA. We can go back to the OMA itself. I'm going to stick in the letter for now, but I do want to take you back to the OMA and go through some of these clauses. But you will see there set out the references to clauses 2.3 and 2.4. If you look, for example, at 2.3.4, one of the obligations was to support Tavistock with the development of any new MPS offering. So this was a broad range of services that were being provided. Remember, in exchange for half of the fee that would be charged. And then at 8 is set out the fact that under clause 3.4, Titan got 50% of the charges. And then we have the provisions in relation to confidentiality. And the reason our definition of confidentiality is broad is because it's broad under the OMA. And so what the parties agreed, that in return for this commercial deal that they've agreed, confidential information was widely defined as all information, however recorded or preserved, disclosed by either party to the other party in connection with this agreement, which is either labelled as confidential, and we see that the investment emails that you've been taken to do have a footer, a confidentiality footer, or which should reasonably be considered confidential because of either its nature or the manner of its disclosure. And the purpose of Brian Raven's statement was to set out and explain why that information should reasonably be considered confidential. And we'll come back to look at that in more detail. Then paragraph 10 of the letter of claim sets out the obligations under the OMA. Clause 5.1.1 prohibits the parties, this was their agreement, that you cannot use any confidential information for any purpose other than complying with your obligations under the agreement. And that's why we say that Titan was not allowed to use any information it gained whilst performing its obligations under the OMA for its own benefit. It agreed that it would use that for the purpose of complying with its obligations in relation to the Tavistock MPS.
I mean, the clause is about information disclosed by one party to the other.
Yeah.
The way you've just expressed it seems to be broader than that, because you said any information which Titan has from performing the agreement, which seems to be on the face of it, a much broader definition.
Well,
can I give you an example?
Yeah,
Supposing you said that there's nothing to stop Titan creating its own MPS. Supposing Titan goes out and sees, I don't know, a Vanguard fund or something, doesn't work on it, does lots of due diligence about that. That's work being done by Titan. It then recommends that to Tavistock. Now, in the way you just put it, that would be information that, in at least one sense, it's got through carrying out its functions under the agreement, but it's not information provided by Tavistock to Titan.
Yeah. Yeah. Well, perhaps we should look whilst we've got this point at the outsourcing agreement itself.
Oh, sorry, I didn't want to take that out of your course, but the way you put it seemed to be contending for a rather broader concept of confidential information than the contract has, just on the face of it.
Well, the contract says all information disclosed by either party to the other party in connection with this agreement. So, in my submission, that is a very broad definition, that all information disclosed by either party to the other party in connection with the agreement, if it's labelled as being confidential, or it should reasonably be considered confidential because of either its nature or the manner of its disclosure. So that's why Brian Raven talks about the investment emails, the information as to what investments Tavistock was looking to onboard has a real value when you are getting that ahead of time.
And you're saying it doesn't matter because of the way in which you construe the OMA, it isn't a case only of information flowing Tavistock to Titan.
Correct.
It's all information that Titan obtains in the course of its duties under the contract.
Yes, because what happened under the OMA was the investment team who were Tavistock become Titan. Titan have not bought the MPS, but we still need them to perform those services. So effectively, although they are Titan, we fundamentally disagree that they're doing their own work. They're being paid for, and they're subcontractors to us, effectively doing the work that would otherwise need to be done by Tavistock. And if you look at that, that's why things such as recital D, each of the parties undertake to act in good faith at all times in their dealings with the other. B, Titan has agreed to provide Tavistock with investment management services to enable Tavistock to deliver its MPS as defined below, including any future adaptations to the MPS.
This is a case which you might have pleaded, but Mr. Purvis says you haven't pleaded because your plea is about information flowing from Tavistock to Titan. So if you disagree with that, you'll need to show us where you do plead this wider case.
Yes, I will take you to that after lunch.
Yep.
I just go back to 5.1 of the OMA again and would ask you to look at that. It's very, very broad indeed, the confidentiality. Each party shall keep the other party's confidential information confidential and shall not, and then these words are very important, use any confidential information for any purpose other than complying with its obligations under its agreement.
But that depends on what's meant by confidential information.
It does.
It's a capitalised term.
Yes, it does. But of course, when you come to look at what is confidential information, of course, that says anything which is reasonably be considered confidential because of its nature or the manner of its disclosure. So the point of Mr. Raven's statement is to explain one of the categories that we do identify in the pleading, the decision to onboard, why that is confidential information. It's not publicly available information at that point in time.
But it still has to be disclosed by one party to the other party to fall within the definition, doesn't it?
Well, but the all information, it is in connection with disclosed by either party, yes, but in this sense that it could be information that Titan discovers about the MPS, how it's structured. It doesn't have to be a specific communication from Tavistock to Titan, because for these purposes, under the OMA, Titan is an insider in this process. It acquires a lot of information about the MPS, and that's why at paragraph 12, all we say of going back to the letter of claim, all details of the Tavistock MPS which were communicated to Titan fall within the definition of confidential information. And then, if you can go over the page to page 6, if you look at paragraph 15, and this is where the copying claim does become relevant and one looks at them together, and we see they're set out at 15. Publicly available information demonstrates that the Titan MPS is a copy of the whole or a substantial part of the Tavistock MPS, including the copyright works owned by Tavistock. Tavistock reasonably believes that the degree of similarity extends throughout the Titan MPS, and that this similarity arises because it was created using confidential information, which were provided to Titan under the OMA. And then if we look, we've sought at that stage to do a comparison. But we make very clear in 16 that we are limited in our ability to particularise the ways in which the Tavistock MPS and the Titan MPS is substantially the same, as it's only able to access certain publicly available documents, such as the latest fact sheets for each model portfolio. Critically, Tavistock does not have access to historic Titan fact sheets or a detailed breakdown of the individual investments and allocations or documents which evidence the investment strategy of the Titan MPS. And that would work the same way if Titan had only had access to the latest fact sheets. Titan wouldn't have had a breakdown of the individual investments, allocations, or documents showing the investment strategy. But of course, as part of the OMA, Titan was party to all of that information. Tavistock considers that an analysis of the individual investments held by each model portfolio over time will reveal a close degree of similarity, and therefore requires disclosure from Titan on the terms set out below. And you will see those were very limited terms. We've been refused even that limited disclosure to do precisely what was submitted to you earlier today we should be doing. What we have done in 17 is to set out and explain what we can tell from the publicly available information. This is the basis for our inferential case. So 17.1, risk profiles. Titan's MPS profiles are based on a 3 to 8 designation of varying risk. This is identical to the Tavistock MPS, notwithstanding that the market range of profiles is 1 to 10, or a bespoke mix. And then you'll see there's a footnote where we've footnoted other things available in the market. 17.2, benchmark. Titan MPS uses the same IA sector benchmarks as Tavistock. 17.3, access to funds. Tavistock refers to these are the emails which you saw earlier. And in these emails, he's issuing a series of requests for funds to be made available to both Titan and Tavistock. Tavistock understands these emails to demonstrate that Mr. Chandler had been instructed by Titan to utilise his knowledge of the funds which were proposed to be held by the Tavistock MPS for the benefit of the Titan MPS, which onboarded those same funds at the same time. And that enabled Titan MPS to directly copy the Tavistock MPS investment strategies. And then rebalancing, the weighting of the holdings within each portfolio was periodically rebalanced. Tavistock suspects that Titan will additionally have rebalanced the Titan MPS at the same time, or shortly thereafter, as executing instruction from Tavistock confidential information received under the OMA to rebalance the Tavistock MPS. And then you will see at page 10 of the bundle, paragraph 31, the very limited disclosure that we asked for. We haven't asked for everything to be able to give more particulars. We asked for these key documents, full details of the investment histories from the 31st of January 23 to the 1st of October 24, including all details of investments and rebalancing, and then copies of all the fact sheets produced from January 23 to the 1st of October 24. There's been a complete refusal to provide us with those. Apologies, I've run over. I see it's lunchtime.
Is that a convenient moment?
That is, yes.
Lovely. Thank you very much indeed. We've gone over a little bit, so I think we should start at 2:05.
Court rises able.